And this process adjustment allows investors to really realize the benefits of residence almost immediately, essentially. The residence itself doesn't come for, depending on the processing times, probably 18-ish months or so, or, sometimes even a little bit longer than that. But the benefits of employment authorization and advanced parole or the travel documents are realized much sooner than that. So even though, as I said, the actual residence is not issued for some time after the filing, the adjustment process does have interim benefits that allow investors to realize the perks of being a U.S. resident and those perks obviously are sort of ability to work for whomever they want and wherever they want, including for themselves, running a business, owning a business, working for an employer and owning a business. You could do all of those things when you have free and clear employment authorization that is not tied to a visa status. And also one thing I want to note is that those clients that are considering U.S. citizenship, they should know that the conditional residence or time spent in conditional residence counts toward the requirement of 5-year residence in order to be eligible for citizenship. So as soon as the investors receive the conditional green card, that 5-year clock starts ticking for citizenship. And of course, there are other requirements that have to be met, but in terms of the 5-year residence, conditional residence qualifies for that period. What I'm hearing from a lot of our clients is that not having job mobility or having the job mobility restricted by the visa status, such as H-1B, is something that is problematic, right? And this job mobility can mean a lot of different things. It can mean geographic mobility. Sometimes people want to live in a different part of the country and want to work, closer to family or something along those lines, right? Or in a different climate, for all that matters. But most often what that means is simply being able to have greater negotiating power when it comes to the jobs you take, the position you have, the employer you work for, the salary you receive, so on and so forth. Sponsorship by an employer oftentimes removes a little bit of agency from the employee to be, because they are dependent on that sponsorship, right? So you don't necessarily have as much leverage in negotiating your package, your position, the location, etc., right? So employment authorization that's based on residence has no strings attached in terms of, again, like employer or location. So investors can work anywhere they want to. They can apply for any job, and so the job application typically says, do you require immigration sponsorship in order to take this position? You can simply say no, right? And that opens up a lot more jobs, basically. It also matters that you can run your own business, right? Like you no longer need to be sponsored by an employer that is not related to you. So you could run your own business. You can also run your own business and work for an employer. Like truly, like essentially it opens up the employment 100%. So they could really work wherever they want and however they want. The advanced parole, travel authorization, it really gives you the ability to travel in and out of the country. You don't have to maintain a visa that is valid. If you had an H-1B visa and you decided that you no longer want to maintain that status, but also the visa is expired, as some countries have very short periods for visa validity. And even though the H status is valid for 3 years, generally speaking, in 3-year increments, I guess, but some visas are only valid for a year. So these individuals would have to extend that visa annually. But once you have the advanced parole approved, you don't have to worry about having that visa valid in your passport. You can travel freely. It also protects this is essential part of the advanced parole, is that it protects your adjustment of status, or your intent to proceed with the adjustment of status instead of abandoning it if you leave the US, right? So it's very important that if you don't have H or L status, you cannot travel until advanced parole has been approved. So this document is an indicator that you have immigrant, you don't intend to abandon your residence. So, having an attorney that, works collaboratively with the client and is, willing to take the steps immediately to correct any issues from USCIS, knows a few venues through which remedy can be pursued, be it through the lockbox support, Ombudsman's office, local USCIS, the IPO, of course. So there's definitely ways to address issues when cases are kicked back erroneously, but it happens. It really does, and I think that's just the reality. And I don't think it reflects poorly on anyone's quality of work or their diligence, but sometimes this does happen. And I've had cases of USCIS writing and saying, we lost your application, could you please resend it? We don't have any of it. Or, we are missing the last 15 exhibits that are listed on your exhibit sheet. We don't have them. The process of scanning petitions, I think, is helping with this, because officers are less and less walking around with bankers' boxes full of papers, but that's still happening. So staying on top of cases, monitoring processing time. If we see a rural petition that has been pending for more than 12 months, it's time to get involved. And actually, I'm in the midst of doing that with one of my clients. It's been more than 12 months. The project that they invested in has had approvals. So I know it's not the project issue, but for some reason, my client's petition hasn't been looked at yet. So we're putting sort of gears into place to, okay, what's going on? Why did this case get misplaced? Really is what it comes down to. But really trying to do that before too much time goes by, because that also impacts the client's timeline. So worst case scenario, a potential investor could be contemplating EB-5, and then a visa bulletin is published for the next month, and it says a visa is no longer available to you. Now you have a backlog. That means they have 2.5 weeks to get that petition and adjustment of status residence filed. This may or may not be possible depending on the investor's source of funds and their ability to put the documentation together, and just how far they are in the EB-5 process. But sort of, it's not all lost. If, should that happen to somebody, you could still potentially make it, but it's going to be rough. So again, I think all of us that work in this space, the best advice we can give to potential investors is, we know it's coming. So if EB-5 is really the right option for you, then now is the time to do it, because why wait and then potentially deal with lack of availability of good projects, because good projects do sell out every once in a while and very quickly. Also, you might be facing potentially expedite fees. If you approach an attorney and you say, I need you to drop everything for the next 10 days so that you can get my petition filed, that's going to come with an extra fee, expedite fee, so on and so forth. So don't put yourself in that position. Do your due diligence now and know it's coming. That's really all we can say. The really important thing for listeners to understand is that the visa bulletin does not necessarily move day for day for a calendar day. So, if it says January 10 on the visa bulletin, and now it's January 21, you shouldn't assume that the backlog has advanced by 11 days. Like, it doesn't work like that. It's actually not even close to that. Like, if you look at some of the historical visa bulletins, which are all available on the Department of State's website, you'll see that it moves actually very slowly, generally speaking. Sometimes it makes great advances, other times it doesn't. Most of the time, it really moves very slowly.